Hello, I'm Joshua Rosenberg, bringing you another edition of A Lawyer Talks. My guest today is Sir Brian Leveson. He's best known, I think, for the Leveson report on the media, but as a judge, after serving as a Lord Justice of Appeal, he became Head of Criminal Justice in 2017. Before that, he was appointed President of the Queen's Bench Division in 2013, and he retired from the judiciary in 2019. In that year, he became the Investigatory Powers Commissioner. And I'm speaking to Sir Brian at your office in London. And I want you to tell me, to begin with, what you do. What is the role of the Investigatory Powers Commissioner?
The Investigatory Powers Commissioner is a role established by the Investigatory Powers Act in 2016 to oversee the use of covert investigative powers across the board. There were previously 3 commissioners, but the Act brought all those roles together, and what I do is twofold. First, along with 13 judicial commissioners, I oversee and double lock warrantry which has been signed either by a Secretary of State or by a Chief Officer of Police. The second responsibility is that I head a team of inspectors who inspect the intelligence community and the police and all those who have any covert powers to ensure, firstly, that what they said in an application for a warrant is justified, and secondly, that what has been done was in truth what was authorised by the warrant, no more, no less.
Let's talk about these warrants in a bit more detail. These give permission for the security and intelligence services and the police and maybe other organisations as well to do things for which they need permission.
That's absolutely correct. Warrantry permits the relevant authority to interfere with the privacy of those who are the targets of the warrant. The warrants are signed by the Secretary of State or Chief Officer of Police, who takes responsibility for its operation. My role and the role of my judicial commissioners in double locking these warrants is to consider them in detail against the metrics of privacy and the requirement that care has to be taken before one interferes with that obligation of privacy set out in Section 2, subsection 2 of the Investigatory Powers Act. So, looking at a warrant, which can be a very complex and detailed document, there's nothing simple about some of these warrants. For me, and indeed the judicial commissioners, we will look at the objective of the warrant, consider its necessity, its proportionality, the extent to which there is collateral intrusion considered, whether there is some less intrusive way of achieving the same result.
But you don't do this for every warrant.
Search warrants, of course, go to magistrates. They're very different. But if the police or the intelligence services want to access your telephone communications or your computer, they need a warrant which does come across the desk of me or one of the judicial commissioners.
And they're mainly retired judges.
The judicial commissioners are all retired members of the senior judiciary. So at the moment there is a former Chief Justice of Northern Ireland, there are several Court of Appeal judges and a number of retired High Court judges.
You mentioned you have a team of inspectors. Where do they come from, or what do they do?
The inspectors are in part former police officers who might have worked in covert activities, or former intelligence officers who will have worked in this area, or others who become interested in the inspection of covert powers and learn the job. There are about 25 of them, and what they do is that they go and inspect the intelligence community and the police and all those who have some form of covert investigative power to check, as I've said, that the warrant was correctly completed and that what was done under the warrant is what the warrant authorised. They write a report which comes to me, and I read and review every single report that goes out, and we report back to the agency as to their activity and the extent to which they need to moderate how they're doing certain aspects of their work.
Obviously, the information you receive is highly confidential, and obviously you rely on the agencies and the police to tell you the truth. Now, the other day, a High Court judge found that MI5 gave false evidence to 3 courts. This relates to its handling of a neo-Nazi agent alleged to have attacked his partner, and the government's ordered an inquiry to find out whether this is false information and deliberately false and therefore a lie, or an innocent mistake, which is what the security service told ministers it was. If they can lie to a court, as alleged, how can you be sure they're not lying to you?
Well, that's a good question. First of all, I have a very good relationship with the heads of each of the intelligence community, and particularly in relation to MI5, who were concerned in this particular issue with Sir Ken McCullum. The relationship is based upon comment that I made very early on and repeat all the time, which is, if you have a problem, tell me about it. I will report on it as appropriate in the annual report, but I will help you solve it. If you don't tell me about it and I find out, then I am going to take a much more aggressive role in relation to its resolution. I can't obviously go into detail about this particular case. All I can say is that Sir Ken came himself to tell me what he was about to tell the court as soon as he made it clear he found out what the position was. So how can I demonstrate they're telling me the truth? Only by going in to check, which I can do. And if an error is reported, then I can send inspectors in to investigate that error. And if that error has caused significant harm to an individual and it's consistent with national security, I can tell the individual in rather opaque terms that they are entitled to apply to the Investigatory Powers Tribunal, who have the power to award compensation in appropriate cases.
And that happened, didn't it, in cases where alleged illegal immigrants had their phones seized?
Well, what happened there was slightly different in the sense that normally I will investigate an error which might have been identified by the relevant service, who are required to tell me about errors, and we check up on them. And in those circumstances, if it's caused loss, I can write a letter to an individual. The problem with the mobile phone collection, which itself raised serious issues of error, was that I didn't know everybody from whom mobile phones had been seized, and that's why I think for the first time my office put out a general letter that if somebody's phone had been seized, they were entitled to apply to the Investigatory Powers Tribunal, who would consider the matter. They can take evidence in secret if it's necessary. They can equally ask me to investigate any matter that comes to their attention, and they have the power to award compensation.
Let's talk about EncroChat. That was this scam, if you like, where the criminal underworld thought they had a secure means of communication, and this was discovered by the authorities, as a result of which a large number of people in various countries were arrested. What can you tell me about your involvement in all of that?
The involvement in EncroChat came in a number of different forms. Normally this would not enter the public domain. It has entered the public domain because it's all been exposed in criminal and civil litigation. So I'm perfectly happy to tell you that which otherwise I would not tell you. There is a power within the statute that allows warrant-seeking authorities to seek advice from my office. That advice is not binding, and I make it clear when it happens that the application for the warrant will be considered by a judicial commissioner who has judicial independence. So I'm not there to give advice. I am there, if you like, to identify areas that they ought to consider as I see the nature of the application. So the National Crime Agency brought the warrant that led to EncroChat exposure, called Operation Venetic, to me. I used the 2 judicial commissioners on duty, so the 3 of us discussed it and gave some preliminary view to the NCA. The NCA then applied to the Secretary of State for a warrant. That warrant came back to my office and it was reviewed against the principles that I've identified before. What's the objective? Is it necessary? Is it proportionate? Has collateral intrusion been considered? Is there any less intrusive way of achieving the same result? And the warrant was granted. That led, as you've identified, to many arrests of serious organised crime group members who used EncroChat as a way of communicating with each other on the basis that it was heavily encrypted and unassailable. The result of that was that challenges were made in court to the suggestion that this wasn't actually equipment interference. This was, if you like, interference in the course of transmission. The great difference between a telecommunications system that is investigated in the course of transmission is that that evidence is not admissible in court. If, however, what is picked up is a stored communication, that's as a result of equipment interference, not, if you like, hacking, then that is admissible in court. So the technical argument in court was this wasn't stored, this was in the course of transmission. But the criminal courts and indeed the IPT have held that it was indeed stored transmission and therefore admissible.
The IPT is the Investigatory Powers Tribunal, and you've already told me that that is a court which has the power to award compensation. It's a secret court, but it's less secret than it was, but it does go into secret session. What's your relationship on a broad level with the Investigatory Powers Tribunal?
The President of the Investigatory Powers Tribunal is Lord Justice Singh, and he has a number of members. There are a number of High Court judges and others concerned with national security who sit on the IPT. I have a regular meeting with Lord Justice Singh, who, not surprisingly, I know very well, and I have spoken to the tribunal members about my responsibilities, and they have helped me on the way in which they look at their responsibilities. The critical relationship is that they can ask me to investigate. So if somebody complains direct to them about the suggestion that they have been intercepted illegally, they can ask me to conduct an investigation, and I can send my inspectors to the relevant agency to do the work, and I will produce a report. Then it is for them to decide. The trouble with the Investigatory Powers Tribunal is that they are limited by national security considerations to what they can say. So very frequently they'll say you have no cause for complaint. That can either mean you have not been investigated, or it can mean, well, you haven't been investigated, but it's entirely lawful. What they won't identify is whether there has been a lawful interception.
And they won't say whether you've lent one of your inspectors to them and that inspector has made investigations, unless, of course, that inspector has found and they've decided that something's gone wrong, I suppose.
What they put in their judgments is very much a matter for them. The Act makes it clear that they can ask me for assistance, and I have no doubt that when it's appropriate, and if it's appropriate, they will identify what we've revealed by way of our investigation on their behalf.
We're well into 2025, and your annual report for 2023 has not yet been published. Now, I fully understand that your report has to be written at the end of the calendar year, and it no doubt has to be checked very carefully by all sorts of people. But it's your report. surely you're an independent commissioner. You shouldn't have to put up with people delaying publication of your report.
This is one of my perennial problems. The annual report is detailed, it is lengthy, and it undergoes, I regret to say, many complex processes prior to publication. It's easy to say that the government are stalling, but I don't think that's entirely fair. The report will be looked at by each element of the intelligence community to ensure that it doesn't reveal matters of national security, not deliberately, but accidentally. It's then submitted to the Prime Minister, having gone through all the other relevant Secretaries of State, and then it has to find a slot to be published. I have been consistently determined to improve the speed with which the annual report has been produced. During COVID, that was difficult. Am I frustrated that the 2023 report isn't yet available? Yes, I'm disappointed, but I know the problems that have been faced, and I hope that it will emerge quickly. But I take your point. I am rearranging the way that we do the annual report so that for 2024 it is well in the course of preparation now, and I am determined to do much better than we've done for 2023.
You could make amends by telling me something that's in your 2023 report about to be published. Maybe some statistics?
What statistics would you like?
I'd like to know the proportion of requests for warrants that are rejected, how effective the warrantry system is at producing the information that will satisfy you.
All right. Well, let's see how we get on. Before I give you numbers, and I will give you some numbers, I want to provide some context. In truth, few warrants are actually refused. Why? Not because we are a rubber stamp. We are most certainly not a rubber stamp. And if anybody suggested to my judicial commissioners that that's what they did, they would not be amused. But the warrant-seeking bodies know precisely what we require within a warrant. And because they want the warrant, they know what they have to do to get the warrant. They have to deal with necessity, with proportionality, these various areas of concern which I've already identified. And therefore it's perhaps no surprise that when they put their effort into drafting a warrant, they do so with degree of care, with a good eye on what we're going to require. So the fact that a warrant is refused is a big deal for them, because of course all that work is then of no value. In 2023, there were a total of 13 applications that were refused, but there were 77 cases where judicial commissioners sought clarification, and for most of these, sufficient information was then provided, or the application was revised by the applicant to enable it to be approved. Of those 77 applications, 2 were withdrawn or no decision was required. In 2024, 12 applications were refused. I can't tell you the number that were returned, but it'll be in the annual report. That isn't us not doing the job, that is us doing the job and making sure that the warrant satisfies the terms of the statute. But you must bear in mind that the discretion in relation to a warrant is not ours, it is that of the Minister or the Chief Officer of Police. What we do is check the warrant for legality, and we generally use judicial review type principles to do so. Not our decision, it's the decision of the warrant seeking authority.
I suppose, looking at these 17 that have been knocked back by you, there must be a level of discretion. We're talking about judicial review. It's not absolutely clear-cut. There is a matter of judgment involved, and your judgment may be different from their judgment. Is that the reason, in broad terms, why these applications were rejected?
They're likely to be rejected because the material did not sufficiently satisfy necessity, proportionality, consideration of collateral intrusion, or some other less intrusive way of achieving the same objective? Has the minister taken into account something which he shouldn't have taken into account? Has something which the minister should have taken into account not been taken into account? Has the minister reached a decision which no reasonable minister could have reached? Judicial review principles of which you will be extremely familiar.
And when we're talking about collateral intrusion, we're talking about, could the agencies have obtained the information they want by listening to an individual in circumstances where they're not listening to members of that individual's family, for example?
That's the point. So there has to be consideration of the extent of potential collateral intrusion, although it's always made very clear that any item that is of no intelligence interest will be discarded.
Can we talk about artificial intelligence? Lawyers, judges, everybody is being encouraged to use AI. Can you tell me anything about your involvement with AI, whether it's having an effect on your work?
AI is certainly a topic which is of great significance in all aspects of my work, and I ought to have made it clear that in addition to judicial commissioners and inspectors and the office generally, I have available to me a technical advisory panel of, I think, 6 experts. 3 of them are professors in computer engineering at highly regarded universities in the country. 3 of them are former computer engineers working within the intelligence community who are very familiar with what can be done. And they advise me and the judicial commissioners on all aspects of internet and IT generally. And they are very concerned with AI. AI systems are being deployed to process, analyze and interpret vast amounts of data, often at speed and at a scale that exceed traditional methods. So these technologies offer operational benefits, but they do require consideration at the lawful, proportionate and appropriate oversight levels as well. So we are principally interested in understanding how the use of AI may increase the number of subjects of interest who can be investigated by public authorities, and how AI may change any intended interference with or collateral intrusion into individual rights of privacy. So our scope is focused on the investigatory powers and any other powers or processes subject to our statutory oversight. So we're going through research into what AI means for our role in respect of the Act, and indeed whether AI can assist us to perform our role in oversight. All these areas are presently being considered, and they have to be considered against the backdrop that the Investigatory Powers Act, created in 2016, was created at a time when the IT framework of the world was very different. And although it was intended to be technology neutral, nobody could have visualized in 2016 that we would have the Internet of all things, SIM cards in fridges or in cars, and how the legislation copes with the developments in IT is one of the challenges that we face.
Do you need new legislation? Do you need more resources?
There has been a recent amendment to the Investigatory Powers Act last year, and there is no doubt that it will need constant review, not least because of the development of the technology. Resources are a difficult problem, not just for me, but across government, and I am keen to ensure that we have sufficient resource to do the job we're required to do. The Home Office is responsible for the provision of finance to me, and they have a duty to ensure that I am appropriately resourced. And I echo the observations of the then Shadow Home Secretary, now the Home Secretary, that strong powers require strong oversight.
And strong oversight, no doubt, requires enough money to pay for it.
You're right.
You mentioned changes to the legislation, and there's one development that I'm particularly interested in for reasons that must be obvious. I gather there is now greater protection for journalists than there was until recently.
You're absolutely right. You will doubtless remember the Big Brother Watch decision in the European Court of Human Rights. And that decision, read in its entirety, effectively created or allowed a recognition of what we were now doing, perhaps not doing at the time that Big Brother Watch started, but there were a couple of areas where it was made clear that some refinement was necessary. One of those was in relation to journalism, and a remedial order was recently passed to correct that position and to bring it in line with the requirements of Big Brother Watch.
And what are the practical effects of that in terms of journalists?
It means that the extent to which journalists are picked out, any review of the material that they might have, has to come before a judicial commissioner for approval for its retention. If its retention is not approved, it has to be destroyed.
And in terms of what a journalist is, I hope there's a fairly wide definition of what counts as a journalist. It's not really a term of art. It's not something that you are admitted to in the way that you become a lawyer. It's not a professional qualification. So presumably the agencies look at information gatherers who publish their information to the public in a fairly broad sense, one would hope.
If they publish information to the public, then I think they're likely to be considered to be journalists. Of course, the problem is going to be those who say they are journalists but actually are not journalists at all. And there are such people.
You must find this absolutely fascinating. I mean, clearly when you were a barrister, you learnt about things which the public doesn't know about as judge. Particularly, you were given access to information that was highly confidential. But this is an entirely new role for you. I realise you've been doing this for more than 5 years now, but it must be absolutely fascinating learning about a world that very few of us have access to.
You're absolutely right. I came into the role as Investigatory Powers Commissioner with very little understanding of the powers that the Act had provided, and each time I have to do some work in relation to either warrant granting, some of which I look at myself, or aspects of the inspection regime that I review all the time, there are areas which are absolutely new to me and are truly fascinating. Unfortunately, that's as much as I can say about them.
But you don't need personally to have had a technical background, to have been a scientist, a computer engineer, to be able to do the job you do.
Just as well, really. No, you don't. But this is the great advantage of the Technical Advisory Panel, because I can ask them to consider areas of technical expertise and then reduce it into language which I can understand. So if you go onto our website, you will see that the Technical Advisory Panel themselves produce reports. There's one on the metrics of privacy. They are working on AI at the moment, and they are fascinating analyses of technical problems conveyed in language which lawyers can understand.
That makes it clear that you personally and the office as a whole feel that it's important that your work is better understood. You wouldn't be talking to me today otherwise.
I'm very keen to make what I do as public as possible. I have a very good, I hope it's a very good relationship with non-government organisations who work in this field, and I meet Privacy and Big Brother Watch and Reprieve and Liberty periodically, and they're constantly seeking that I publish more. That's not always possible, but I was always of the view that it was much to the benefit of society that they understood what we are doing in their name. And that was a view I had when I started in 2019. Of course, then COVID interrupted everything. And it's only more recently that I've been able to find avenues to talk more broadly about the work that we do. And I'm keen to take those opportunities, including talking to you.
So, Brian, you report to the Home Secretary in terms of your day job, but you've also got a part-time job of no little importance reporting to the Secretary of State for Justice, Shabana Mahmood. And she has asked you to look at the criminal justice system. Now, I know that's not the purpose of our interview today, but we know that you've got a recently appointed advisory panel. We know that the Justice Secretary wants you to report by the spring, the late spring, perhaps the early summer. What can you tell us about the progress you have been making in reviewing how the criminal courts work in England and Wales and the prospect of a report to the Justice Secretary on which she can act?
When I was asked to take on this additional role in mid-December, I called for submissions and have received over 200 submissions since then. We are analysing them at pace. Of course, there is a very great deal of background material which is in the public domain. One only needs to go to the Royal Commission, chaired by Lord Runciman, or the report prepared by Lord Justice Old, or indeed my own review of efficiency in 2015, to see the ideas that are available to try to address the very real problems that the criminal justice system are presently facing. I hope to be able to report within the time frame that the Secretary of State required me to, but at the moment we're simply working at pace going through it.
Sir Brian Leveson, Investigatory Powers Commissioner, thank you very much indeed for your time today. I'm Joshua Rosenberg, and you've been listening to A Lawyer Talks.